Government is proposing to make the failure of people to declare items being brought into the country a criminal offence. This is one of several changes it wants to see as debate on the Miscellaneous Provisions Mutual Assistance in Criminal Matters Proceeds of Crime FIU of Trinidad and Tobago Customs and Exchange Control Bill 2017 began in the lower house. Rishi Harrynanan has the details.
Attorney General Faris Al-Rawi said bearer negotiable instruments should be looked at as cash. A BNI or bearer bond is a type of fixed income security where no ownership information is recorded and the security is issued in physical form to the purchaser. The holder is presumed to be the owner and can use it as a coupon. The AG said there is a loophole when it comes to registering this and as such is proposing to treat this as cash to ensure it is declared when people enter the country. However, it must be approved by the central bank. If not, there can be serious repercussions.
Under 20,000 TT dollars, you can bring it in. Over 20,000 TT dollars, you must declare it. It's if you don't declare that you're liable to the provisions of Section 212, 213, 214 of the Customs Act, where you can have forfeiture, etc., or you go down to 286, etc., where there are enforcement mechanisms in the customs laws of Trinidad and Tobago, which are pre-1962 laws, I might add, but which work quite well.
The AG also described as dynamite the legislation governing the Customs Division because it seeks to give very important strengths to the post-audit period for customs. However, he said proper supervision cannot be implemented as the period for record keeping is too small and it was not an offence to refuse to keep records.
And what we have done in this law is to allow for the customs authority to not only prescribe the time frames in harmony with that which we do in the Income Tax Act, which is to take it to 6 years. So you're bound to keep your records for 6 years, not only the consignee or the importer, but also the customs officer. But you're also required to produce the information within 30 days. And if you can't do it within 30 days, such periods may be extended, but for not more than 3 months.
Additionally, government wants to make money laundering a summary offence while keeping it as an indictable offence. The AG said, as it is, 17 individuals are in court on 51 charges of money laundering, which amounts to millions. These matters have been before the court since 2012. However, they have not passed the preliminary stage.
We remove the prescription against indictment only, and we now add, by way of an amendment to Section 53(1), that you can take the offence as a hybrid offence, or you can go either way. Specifically in Section 53(1), we propose that for a summary route, that you have the ability for the offence to be met with a prescription of up to $25 million, not in that language obviously, and 15 years imprisonment, and for the indictable route that the offence is met with prescription of $50 million and 30 years.
Changes are also being proposed to the Financial Intelligence Unit to give it more teeth in carrying out its duties. Rishi Harrynanan, CNews.
Meanwhile, Member of Parliament for Caroni East, Dr. Tim Gopi Singh, said the changes to the bills are an infringement on the rights of the people of this country.
And some of the fines that I will speak about subsequently are, in fact, onerous and cannot be accepted in a nation when you want to fine people $50 million and 25 years imprisonment for a matter of a civil matter.
Dr. Gopi Singh also questioned the reason for making money laundering a summary offence. He said the courts are not equipped to deal with these matters.
You know that in San Fernando Magistrates Court, they run on a shift system already.
That is true.
So how, with that type of weakness and ineffectiveness and inefficiency in the magistrates court system, where you have to have a court running on shift, how are you going to implement these matters from a money laundering perspective and have it done successfully? And you yourself said that out of these 17 charged with money laundering in 6 years, not one of these has been successfully prosecuted.